So my name is Bruce Zutler. I'm the organizer, president of this association, and we're here to help all of you figure out a more intelligent way to, not that you're not intelligent, okay, not wrong, to launch products and continue on your journey to understand a better way to commercialize. We have a couple of professional members that help support the organization. I'd like to recognize them briefly before we get on. Gordon, would you like to say hello? Okay.
Hi, I'm an industrial designer, product designer. Love working with inventors, and I'd love to talk with any of you who would like to work with me. I do engineering, product design, make it look good, get it ready for manufacturing. So anything along those lines. In fact, sometimes Bruce and I work together. So get a hold of me. Thank you.
Thank you, Gordon.
Thank you.
Also, I want to thank Troutman Sanders and Lewis, who's usually here. He's an intellectual property attorney. He's our host here. He couldn't attend tonight. He's been here religiously, and he gave a great presentation last month. So just want to thank Troutman. And Trenda, just want to say hello, raise your hand. She's from Troutman in Lewis's stead this evening. And there's a couple of others who might show up a little later. But let's get on with it. And I want to introduce you to Randy Friedberg, who's our speaker this evening. And I've known Randy for a few years. And what struck me about Randy is his practical approach to protecting his client's interests, but understanding also what startups have to go through and things that are just not commonly discussed. No cut at a patent attorney, but patent attorneys usually are very good at writing your patents, but they may not fully grasp all the details of your business entity and such like that. And that's where someone like a Randy comes in. He has a nickname, which he's going to blush now. He's known as the Hammer. That's not to say that he's a shark, but he balances that with a real-world perspective and a heart, too. So with that, though, it's a pleasure for us to have Randy. And Randy, please.
Thank you. Thank you for having me, Bruce. And if you ever tell people that again, I'll let to talk to you. Just for the record, I didn't give that.
He's known as the Hammer.
That wasn't my own nickname. That was from a client. So, as Bruce said, my name is Randy Friedberg, and I'm here to talk to you guys today about legal issues that you should think about when you're starting up, when you're going from a concept in your head to actually starting to think about commercializing. So I have a presentation that's 43 slides long, but I want to say something first. If you have questions, jump in. Nothing makes a presenter, or at least me, more frustrated than when I'm sitting here droning on for an hour and you can't tell if people are awake or not. So I'm serious. Please just jump in with questions if you have them. If you don't, you'll just listen to me talk for an hour, I suppose. So I work at a firm that's 250 lawyers. We're based in Philly. I'm in the New York office. We have offices in Delaware and Boston and all over the Eastern Seaboard. And that is actually quite an advantage because most incorporations are done in Delaware, which means that most lawsuits are brought in Delaware, which means that if you don't have enough in Delaware, you have a problem. It means you have to get local counsel. So for us, that's a huge thing. Our clients range from funded startups to literally Google. We're all over the map. Our sweet spot is mid-sized companies. But you know, I've dealt with a lot of people just like you guys. I know what the struggles are, and I know what you should look out for and what you should not look out for and what to care about. So what we're going to talk about tonight are some of the main issues. The first two slides are just an outline of what those issues are going to be. We're going to talk about why you should care about legal, incorporation issues, third-party issues, IP issues, equity, founder's equity, which is different than third-party equity, what you should budget and what you should really budget, because if any of you have ever done this, whatever your budget is, whether it's $1 or $1 million, it's going to cost you 2 to 3 times that much. How do you make and sustain yourself, and what happens next? So, why do we care about legal? Let's start with that. And the answer is, first and foremost, you want to limit your liability. What do I mean by that? You don't want to put your lives at, I hate this clicker. You don't want to put your lives at risk to start up your company, right? So the way to do that is you want to think about where you're going to put this item that you're going to do into a little box so that you can get your business going, but you're not going to put your house at risk. So you want to do, we'll talk about that in a second, how you do that. You want to worry about third-party rights. You want to worry about whether there's somebody out there who thinks they already invented what you invented, or whether they have a trademark that's similar to your trademark, or they have artwork that's similar to your artwork. You want to think about how to structure it. And one of the reasons you want to structure it properly is tax avoidance. Very big issue that a lot of people starting out don't think about, but they think about it within the first year if they actually get it off the ground when they get crushed with taxes. So it's really important to think about these things and do them right at the beginning. You got to have the right business structure. What are the options for the business structure? Well, mostly it's going to be incorporation. Sometimes, especially if it's an unfunded startup and you're doing it on a shoestring, you'll find clients that are just doing it with their best friend or with their spouse or with a guy they meet on the street, and it's always dangerous. Because, number one, you want to have liability issues. You want to avoid liability. If you form a corporate entity, the idea is it allows you to conduct business without having liability passed to you personally. If you don't form an entity and you're just doing it as a quasi-partnership, liability is for everybody. Joint and several liability, not a good idea. Tax issues. We'll talk about C Corp versus S Corp in a second, but what you want to do is not get double taxed. You don't want to pay corporate taxes and then personal taxes. By the way, as an aside, I've done many presentations in my life, and every single time I feel like I'm going too fast. I have a lot of stuff to cover. If I'm going too fast, someone say something. Is everyone awake? Someone tell me. All right, just checking. Okay, that's all I wanted. Investors. Investors look for a certain structure. If you want to go outside and get third-party money, they're going to look for a structure. I'm not talking Kickstarter, I'm talking real investors. We'll talk about that in a second. And then for public, it gives you a credibility, I think. So think about that. Okay, as I said, avoid the de facto partnership. That's where you just sit down with your pal and you start doing things. Who owns everything if you do that? If two people sit down together and they're brainstorming and they both have an idea, and Bruce thinks it's his idea and I think it's my idea, and then later we break up, what happens? Well, it's going to be fact specific, but what really happens is a nightmare. So it's a very bad idea. And then vicarious liability. Bruce and I are deciding to launch a business together, and we don't bother doing anything corporate-wise because, you do as I say, not as I do, because I'm an idiot, right? Bruce then goes out and he gets into a car accident while he's on company business. What's going to happen? Bruce is going to get sued, and I'm going to get sued because we have joint and several liability. Bad idea. So what's the fix? The fix is to form some sort of corporate entity. What kind of corporate entity do you want? Well, there's LLCs, which is really what people do nowadays. It gives you the most leeway. Yeah. There's also S Corps, C Corps, forget B Corps, we don't have to talk about nonprofits. Let's just focus on limited liability companies, S Corps, C Corps, and partnerships, okay? So S Corps and C Corps are the simplest. What's the difference? Anybody have any idea? Okay, everyone, thank you for reacting. So an S Corp just means that you form a C Corp, and then you do what's called a sub-S election. And that's an IRS thing. What it says to the IRS is, I'm electing to have this small type of corporation, I'll talk to you in a second about what the requirements are, so I don't get double taxed. So I have the protection of the corporate entity, I can't get personally sued as long as I follow the corporate formalities, but I don't have to pay corporate tax. The taxes just go right to my personal tax returns. It's really, really good. The problem, so essentially S and C are the same thing, you forward them the same way, you just have an extra step when you do an S, okay? The problem with S is, it's very limited in what you can do. You can only have a certain number of shareholders. You can't have corporate ownership. In other words, a corporation can't own an S Corp. You can't have foreign ownership. So it limits you in a lot of ways. So the simplest fix is to form an LLC. LLC is a limited liability company. It sort of combines a partnership and a corporate entity and the best of both worlds into one. You get your liability avoidance, which is really what you want, and you get your tax pass-through, which is also what you want. There's a lot of more complex differences that I'm not going to go into, but bottom line, if you're going to form an entity today and you're not worried about bringing it to a hedge fund or a fund to raise money right down the road, form an LLC. The reason I say that is because LLCs aren't direct ownership and they oftentimes want to see a C Corp, but let's not worry about that right now.
Later, can you go from LLC?
You can convert. You can convert. not that complicated, not that expensive, and happens a lot. And by the way, it doesn't matter a whole lot because no matter what you do up front, if you're gonna bring in outside real money, they're gonna wanna redo all the documents anyway. So the one thing to know is that if you're gonna form an LLC in New York, you have to publish it, all right? And it gets expensive. And it used to be that you'd say you publish, you never did, but now they actually enforce it. So it's the price difference is it's $300, $400, $500 for a C corp or an S corp, and it's a couple of thousand by the time you're done with a LLC. And that's without the operating agreement or shareholder agreement.
Is that also, I know a lot of people file
Don't
in
interrupt.
Delaware.
Yeah, we're gonna talk about that in a
Okay.
second. There's a lot of reasons to put. Let's go do that now. Oop, I'm going backwards. Okay, so why does everybody form in? Not everybody. Why is it very common to form in Delaware? And you all know that Delaware is where you're supposed to form, right? You've all heard that before. No? Okay, Delaware is one of the main jurisdiction people form in. Number one, it has a very low tax structure. Number two, it's a very well developed body of law, and it's cheap. It's where you want to go. And, you know, being a lawyer, all of these things have 27 different moving parts, because if you file in Delaware and you're based in New York, you don't have to qualify to do business in New York. It's still what you do. So my suggestion is, most of the time, I would tell a client file in Delaware. You can file in New York. You have liability issues in New York. If you have employees, you may not want to be in New York. But for your purposes, Delaware is ideal. And you got to choose a name. Now,
Randy, excuse me one second.
Yeah.
Can we back up? So most of the people in the room are New Yorkers. They file in Delaware and they file taxes in New York.
right?
Do you have to file taxes in Delaware?
Yes. You have to file, at a minimum, your franchise tax in Delaware. But it's fairly low. It's fairly low rate structure.
But does it affect how you might interact with subcontractors or get an employee here in New York if you're a Delaware corporation?
I'm not sure I understand the question.
A Delaware corporation, a New York resident, you file New York taxes, you have to file a franchise tax in Delaware. But does it matter if you have employees that are New York based?
Yeah, because you're going to be, yes, because you will be doing, yes. If you have employees in New York, you will be doing business in New York, and you have to qualify, and you're going to have to file in 2 states at that point, for sure.
Okay.
But I would tell you that this conversation is way beyond the scope of this presentation.
Either way, it's still he's just doing it in New York.
No, you could easily do in New York. There's many differences. One of which is if you file in New York and you have an employee, you, the owner of the company, are personally liable for that employee's wages. In other words, you don't get the shield for wages. In Delaware, you would. So there's just a lot of moving parts. Yeah.
When you talk about filing in Delaware, are you including the LLC or are you just talking about corporation?
Both.
Both?
Yeah, I'm using them interchangeably. Doesn't matter. And again, if you want to file in New York, that's fine too. It's not gonna be a make or break for a startup on any level.
What kind of cost difference are we talking about between the two?
They're comparable. Delaware's a little cheaper than New York, but again, the kicker is, regardless of which one you form in, you're gonna have to publish. So if you're an LLC, if you're a C corp, you're not gonna have to do that. If it's a C corp or a sub S, you're talking $300-400, in either jurisdiction, really. Yeah.
What is the purpose of publishing?
It's a requirement under the law, number one. The real purpose is, you do the same thing when you form a partnership. It's to put the world on notice that you formed this entity and that it's out there.
Publishing on any newspapers? Is it
There are specific newspapers, there's specific newspapers that they accept, and it's the cheapest way to go. Yeah,
If you're a New York corporation, can you switch to Delaware?
can you,
Go to Delaware, can you switch to Delaware or you
yeah,
have
you
to go to that?
can, yes. You probably have to reincorporate and then do a merger, but yeah, you can always do that. But there's no, unless you're gonna do a fundraising round and the entity wants to see you in Delaware, I'm not sure it matters a whole lot. So this is a really quick process. It's a super important process, and it's not a time-consuming process. If someone called me tomorrow, or you can do it on Zoom, legal Zoom. I don't recommend it, but you can. I have clients filing trademarks on legal Zoom, and then they call me to fix it when they screw it up, but it's doable. There's a bunch of things to keep in mind though, okay? You form You call somebody, you form the entity. You gotta have a name. A name, there are rules about the names. There can't be another company that's got a similar sounding name in that jurisdiction. If you come across a name you like in New York, you can go form it in Delaware under the same name if it's not already there. Each of these is very geographic, different than trademark registrations, for example. Okay? You have to appoint directors and adopt bylaws. That should happen fast. Because here's what happens a lot. Clients, especially the little clients, will form an entity and then ignore all the corporate niceties. They won't do bylaws, they won't form board of directors, they won't have organizational minutes, and you know what happens then? You might well have not wasted the money because you've given away your protection. You gotta follow the corporate niceties. It's very important. You get what's called an EIN number, which is basically a social security number for a corporation. It allows you to open a bank account, it allows you to function. It's free. Doesn't cost anything. It's a free form that the IRS gives you. And then you should issue stocks. Or if it's a C Corp or S Corp, you issue stock. If it's an LLC, you issue membership interest, which is the equivalent of stock. By the way, I don't know, how do you work? If anyone wants this presentation afterwards, don't worry about taking notes. Just, you'll have my contact information at the end. Just send me an email and I'll be happy to give it to everyone. Or you can take pictures of every slide if you want. So the point is, you can be up and running with a company really fast. But be careful and don't overbuild. Don't create a ridiculous structure where you have your holding company and 17 wholly owned subs that you do God knows what with. It's just not necessary, and it's going to create a lot of expense and complications for you, all right? It's also going to be a problem if you give away rights to too many rights or too much equity, because at some point you're going to want it and you're going to need it to do fundraising. Put a team together. A little bit self-serving, but also true. You got to get the right attorney. You got to get a board of directors. You got to get accountants. You got to get an advisory board. It depends on what you're doing, but these are things you should all have. And let me just say, I'm going to say this again because no one ever listens to me. Equity is expensive. Be careful about giving away equity. If you think your company is going to be successful, then that equity is going to be really valuable. And if you don't think it's going to be successful, stop wasting your freaking time. All right? So what happens is you start up a company and you figure, I only have $100 to do this. I think I'll give away 90% of my equity, which doesn't cost me anything. All right? And then next thing you know, you have 10% of your company and you haven't spent your $100, but what are you wasting your time for? All right? And if you take one thing away from this entire presentation, equity is expensive. Counterintuitive, but very true. All right, third parties. What do you have to think about with third parties? You got to think about employment issues. Is the person that you're working with, are they moonlighting someplace else, or are they moonlighting for you? Do they have obligations to someplace else? Who owns the IP? Let me give you a quiz. I decided to hire Bruce because I want to create a new website. Bruce is an IT genius. I tell him I want the website to look blue and pink with green polka dots, and here's the text I want it to say, and here's what I want, here's the functionality I want it to have. I give him $10,000 and Bruce delivers it the next day. Who owns that website?
Bruce.
You do it.
Why?
Because he developed it.
But I paid him for it.
You had a work for hire agreement in there.
Ah, good. I get
They've
this.
been listening the
That's
past few
nice. All right, very good.
Explain
Yes. So there is something we'll talk about a little bit further, but there's a concept called work for hire. Okay, what does that mean? That means it determines who owns a copyrightable work. Okay, so that's any original work of creation, any sculpture, a textual work, a book, a website text, design, anything like that. Software. There's a bunch of different ways to own it. Number one, if it's a company and it's done by an employee acting within the scope of his employment, the company owns it, not the employee. Number two, you buy it by assignment. So Bruce creates it, but I buy it from him, he assigns all right to me. Number three, I want Bruce to do it, to create it, but I want to own it from inception, not as an assignment. We do a work for hire agreement. And it has to be done in advance of creation of the work, and it has to say it's a work for hire done by Bruce for me. Okay? And that's the only way I can, as the client, own it. as I said, being a lawyer, there's always wrinkles in that, because there's other rules. There's 9 things enumerated in the copyright statute that has to fit within one of those 9, even if you call it a work for hire. If it doesn't fit within one of those 9 things, which is a contribution to a collective work, an audiovisual work, a map work, a mask work, doesn't matter. The point is, you want someone who actually knows what they're doing, because if you fake it and you do the wrong thing, you're screwed. The other thing we always do, if we have a work for hire agreement, we do an assignment in the same document. So you say, this is a work for hire, and oh, by the way, in case it's not a work for hire, Bruce assigns all his rights to me. You have that one tip. Second most important thing, after the equity thing, work for hire. Because I can't tell you how many times people I've worked with have built up companies and then realized, whoops, crap, I forgot to own my stuff. Bad.
So is there a standard format for that, or
Yeah,
is it customized to every single company that you do a work for hire for?
There is a standard form you can find online for free. It's better if you hire me to do it.
Okay.
But the truth is you don't need to.
This may be a question you can answer after, but is it, what if no money is exchanged hands, like what if it's a barter or a friend? Like when you're starting out,
has to-
helping everybody.
That's contracts 101. There has to be consideration. There has to be something given up on both sides, otherwise you don't have an enforceable contract. I don't care if it's a work for hire or a real estate lease or anything, you have to have something traded. What's traded can be money, can be rights, can be the right to not do something, can be obligations, but they have to have an
So
exchange.
rights, not just, in other words, excluding them from
Yeah,
any rights.
there's a gazillion ways to do it. Oh, thank you. But yeah, you have to have some exchange. Yeah.
Just to be clear, if you didn't have a work for hire at the outset, and then later on you wanted to have the ownership of those rights,
You have to do it by assignment. You can't do work for hire after the fact.
you can't refer to it?
No. Why does that matter? That's a more interesting question, actually. Why does it matter if I own it by assignment or by work for hire? If anybody knows the answer to that, you're going to come up and do the rest of this presentation. Okay, here's why. Because under the copyright law, there's something called take-back rights. What are take-back rights? This is really funky. I love this. 35 years after a work is created, the creator of the work gets to take it back. So I do a contract with Bruce, he assigns me some software he wrote, and it turns out to be Google or Microsoft. 35 years later, he gets to take it back for free. And you cannot contract that right away. So no matter what I say, if I say, I'm buying it from you and your take-back rights are gone, guess what? They're not gone. Why do they, I'll get to in 1 second. Why does that, it seems a little funky. And by the way, it's a really hot area because if you think about rock, for example, all the really big 70s songs, in early 80s, they're coming up for renewals. They're coming up for take-back rights now. So all the publishing houses and the record labels that screwed the artists originally are getting back their rights. The artists are getting back their rights, and that's why they did it. Because the Congress realized that when you're struggling starting up artists, you don't have any negotiating power. So poor little Brucey, who's just starting up writing coding, comes to me, I have money, I'm gonna screw him. And then 35 years later, if what he's created is still valuable, you can take it back. Happened with Disney and Winnie the Pooh.
In its entirety?
In its entirety. It's like I never existed. Now, sorry, go ahead.
You kind of just answered my question. I was going to ask you, doesn't a patent only last 20 years? But
We're talking about copyrights. Distinguish between trademarks, copyrights, patents, and trade secrets, which we'll talk about a little bit further down the road.
Gotcha.
Because I know it's a little confusing. This whole conversation was just copyrights.
Randy?
Yeah.
So if it is assignment at inception, work for hire
Yeah.
with immediate assignment,
Yeah.
is the take-back right?
Work for hire is not an assignment. Work for hire does not have an assignment. That's, sorry, you're
Okay,
right,
so-
you connect the dots. So the difference is, if it's an assignment, you get to take it back. If it's a work for hire, there's nobody to take it back, because I already own it. I owned it from the minute he created it. So you don't have take-back rights in work for hire. That's the fundamental difference. Clear to everybody?
Yep.
Okay, you also have, you may want to think about non-compete provisions. Everyone knows what that is, yes? Non-solicitation provisions. You got to think about immigration issues. Is my key employee coming from a country and I need to get him a visa? And don't just think about employees, it applies to founders as well. If Bruce and I are starting a company and we're both completely important to it, we better make sure we have all this squared up. I have a startup right now that's going to be, I think it's going to be a $50 million company within a year, okay? And they're coming from another company where they're competitors. And they don't have any non-competes, and they're spinning off this whole new thing. And the company they're leaving had no non-solicits, no non-competes, and as a result, they've screwed themselves. I like that. Yeah, there's a house in New Orleans. Most startups tend to be too quick to hire and too long to fire. Once again, equity's not cheap. Don't hire someone just because they're willing to work for a piece of the pie. As things get more complicated, it's going to be more valuable. It's great to work with friends and family. It's very hard to unwind things if you start working with friends and family. Sometimes it's great, but just know what you're doing. Be careful about people. I'm sorry?
Not usually.
Yeah, not usually. It's not usually a great idea.
No.
But, you know, sometimes if you're in startup mode and you don't have any money, your mom's the only person you can find who will work for free.
So is that where you throw the work for hire in there as much as you could? Or
With your family? Well, yeah. Well, remember, work for hire, are they stuffing envelopes or are they helping dress coding? Because we're only caring about someone who's creating new copyrightable works, right? Software, my website design.
Designs of
Yeah,
products,
designs are-
prototypes
designs-
and stuff like that.
That's, well, it's complicated
Yeah.
because a design that's not separable from the utilitarian aspect of the design is not copyrightable. So there's a very famous case called Keelstein Court, and the case was, it's a belt buckle, okay? And they registered the belt buckle as a sculptural work. And the question for the court, in the Supreme Court was, that's a belt buckle. Is it registerable in copyright when it's a utilitarian object? And the court said, the belt buckle is not registerable, but the artwork that's separate from the belt buckle is registerable. I realize I'm getting way, this is esoteric IP law. that
No,
you
it's
don't-
fine.
It's applicable, I think, for a lot
Okay.
of us.
Avoid those with checkered past. You know, Bruce did a stint up in, no.
You weren't going to tell.
It matters because at some point you're going to want funding. And when you go for funding, somebody's going to do background searches on your main people. And when they find out your third in command or second in command has done a stint for fraud, they're going to run. So be aware. And then most importantly, and probably most difficultly, recognize your own limitations. Very, very important. None of us can do everything, at least not well. All right, so you got to bring in help when you have to and can afford to.
Are there any risks, like just like working, like somebody says, oh, I just
I'm
want to
sorry.
help, sorry, I just want to help you. Somebody says, I just want to help you out and like with something in your,
Yeah.
with your business. What
Yeah.
risk, what risk
Run.
are there? Yeah, lots?
Did I do that? Listen, yes, there are organizations that'll do that, and yes, there are people. There was Mother Teresa, but most of the time people are self-motivated, right? So someone who just wants to help you for the good of helping you and doesn't want to get paid, maybe it's just a lawyer in me, I don't know. If nothing else, I would want to paper the hell out of it, and if you paper it and they don't balk at that, okay, then you got really nothing to lose. But if they say, I'm not signing anything, I'm just doing you a favor, it's going to be an expensive favor.
And many of you may have heard me tell the story about company people came to the Inventors Association, and that day they had hired an engineer at a very reduced rate. And the topic of work for hires came up. And the next day they called the engineer and he said, oh, I thought I was going to be a 15% owner. And they didn't have the work for hire defined, so the copyright of the work would have remained with the engineer. And they were able to unwind it very quickly. So,
Interesting.
you know, as Randy says, run from people who just want to do things for free or what seem to be bargain deals. There might be a catch.
There's always a catch. I have a client right now who spent, I can't tell you what the concept is, but he spent $300,000, literally $300,000 having some proprietary coding created. And it's with a real company, and the company, and he hadn't signed any final documents, and they kept saying, yeah, don't worry, work for hire, don't worry about work for hire. And then he did some testing on the coding they did and found out it was garbage. But he wants to at least own it for the $300,000 he paid them and then build from it. They said, oh yeah, if you want to own it, give us another $150,000. He said, what? That's not the deal? And they said, tough. So guess what? We're suing them now. don't know, somehow we got far afield on protecting your IP. But I guess it seems like it's an area of some interest, so that's fine. Two typical approaches. People contribute IP in exchange for equity, or there's a licensing arrangement. In this situation, we're talking about a license in and a license out. The major thing to think about here, there's a lot of things, but the major thing to think about is, if you're gonna go for financing, and you want someone to put in money to your company in exchange for pieces of for equity, are they gonna want you to own the IP, or are they gonna want you to license the IP? Nobody? Well, if you were putting money in, would you want someone to have a license that can be terminated, or would you want them to own the damn thing? You want them to own it, right? If I'm gonna go put money into Bruce's company, if he's licensing the equity, the IP from you, you can walk away from that at some point. You can breach it, you can terminate it. And therefore, my investment in Bruce is meaningless. If Bruce owns it, I can always go after the company to get my money back. Okay? Does everyone understand that? Yeah.
So, if I have a patent that's under my own name, and I have an LLC, let's say that somebody has an issue with my patent or whatever, am I personally liable, or for the patent, is there any liability with that?
Oh, yeah.
Yeah.
Huge liability. So that raises two issues, okay? First issue, are you gonna then, if you're gonna do the business that the patent practices through the entity, or if you're gonna raise money into the entity, you're gonna have to most likely assign that patent to the entity. In doing that, you're giving up your IP rights, but you're also getting some liability protections, because now if someone sues, they're suing the entity, not you. Right now, if they think you've infringed their whatever, they're coming after you. So a lot of times inventors want to hold on to their IP and then license it to the entity, figuring they'll get two income streams. The entity that they formed is going to get paid because it's going to raise money and then do business, and then they have to license it from the inventor. So you got two income streams there, except that it doesn't work. Sometimes, but unless you invent something really amazing, it's very unlikely to work. And you also have the liability issue.
Randy, this may be too case specific, but if the inventor licenses it to the company, but the patent is like an implementing patent, and the company does a version of it, and that version is the infringing element, is the inventor still liable?
So you're saying the entity has created a derivative work based upon the underlying technology?
Correct.
No.
The inventor is not liable.
The inventor's not liable.
So it could be licensed in an early stage for the company to develop something specific. And you could still retain control of the IP?
Yeah, except you're gonna have a hard time raising funds if you do that.
Okay, got it.
Right? So let me put this into context that's not startup. I had a client that's a very large accessory company. They do a lot of different brands. They license into brands, and they are huge, okay? There was this very well-known streetwear brand that was on its heels. It's one of those companies that was up $1 billion one day and down $1 billion the next day, and it was on one of its downward trends and needed money. So it was gonna license its IP, its trademark name to my client for 10 years. But it wanted to get paid all up front. You know, mid seven figures, all up front. That's not normal. You never do a license deal like that. Why don't you do a license deal like that? It goes to what I was trying to explain to you before. Because the second I've paid you for licensing your rights, what's your only motivation? Find a way out of that. So you keep the money and then go give it to somebody else, right? So it's a very dangerous practice. You want to have ownership, not licenses, if you're going to invest in a company. That just confuse things or make things easier?
That makes sense.
Helpful, thank you.
I don't know what time I start. How long do you want me to go? I can go for another 2 hours, another 20 minutes.
2.5.
Yeah, it's 45 minutes.
Okay, so we're back to what we've been taking our side thing on, our little conversation. Again, the employer owns the IP unless the employee developed titles on his own time and did not use employer's equipment, right? So remember I said it's owned by the employer if it's done within the scope of the employee's employment. So let me tell you about a very famous case. I've actually done a whole hour presentation on just this one case. It was Mattel versus the Bratz dolls. Anybody know about this? Okay, so, anyone heard of the Bratz dolls?
Yeah.
Okay, if you have a little girl, you know these. They're like Barbie on steroids. They were these badass dolls that were like Barbie with an attitude, okay? Mattel owns Barbie. One of the product designers of Barbie, he said on his own time during vacations, created the Bratz line. Bratz line launched and was $1 billion line within 2 years, and Barbie was down in the garbage. No one was buying Barbie, everyone was buying Bratz. And so Mattel sued the creator of the Bratz line, saying, hey, we paid you to do doll design, this is a doll, this is ours. What happened?
They won.
Who won?
The Barbie one.
Yeah, Mattel did not win.
I thought Barbie
Actually, Mattel did win and then lost an appeal, and then it was sent back, and then it went back and forth 5 times. The net result was Bratz people won. The guys argued he did it at his mother's house during a vacation, not using his work time, not using work materials, and so he got to keep his rights. But I have to tell you, that's a really close call. That went back and forth 20 times.
That's during the term of employment period, 90 days, weekends.
But if I'm employed by you and it's within it's still my job to create dolls. I don't know how it would have gone. That could have gone either way. My point is, you're so much better off having an agreement that spells everything out properly. Because you don't want to have this was a, I don't know, $25, $50 million lawsuit. This is not something you want. Trust me. Okay.
So, are you suggesting that any time that you create something or that you're hiring somebody, any of your employees, you want them to sign an agreement that says, anytime you create anything 24/7, it's for me?
I don't think you get an employee to sign that, right? You wouldn't sign that, would you?
No.
If you work for me and you're creating new pharma products and you go and create a website that sells children's clothing, I should know. Why would
That's
I
going to be
know?
related to the industry.
Well, yeah, I mean, that's what I would argue. And I think the 24/7 is tough to say. There's a bunch of ways to deal with it. One way to do it, you can simply carve out any IP that you come into the relationship with. So if I'm your employee, if I'm working for you, I have to specifically list all the IP I'm coming in with. And anything from that date forward is yours. But that way I get to carve out what I was working on already.
So Randy, what might be pertinent to a lot of the people in the room is if they are working as an employee for someone now, what do they have to watch out for?
It's more about the employer than the employee.
But if
It depends if you want, listen, this will work for higher state. So is New Jersey, employee will state. So are most of the states around us, which means you can be fired from your employment at any time without cause, so long as it's not for an unlawful reason, right? Discriminatory, whatever. So why do we bother doing employment agreements? If you don't have a specific term, the reason is to set out things like non-compete, non-solicit, and employee who owns what. And so, it's just, like most things in life, it's a question is who has the bargaining position and what you're trying to protect.
So if there isn't an employment agreement in place that specifies non-compete, or...
If you're the employee, I wouldn't raise the issue. If you're the employer, I
So
would.
if it's not specified, they don't have to worry about it. But if you do have an agreement and you do create something you think is unrelated, you potentially may still...
You still may have a problem, especially if it's big.
Is there any statute of limitations, like how long you could quit before something can be invented? It seems like it was derivative, but you took some time
It's
off.
very fact specific, you agree.
Yeah,
It's not like if I quit today, 3 months and 1 day later, I'm clear.
If Mattel lost the Bratz case, I'm taking my chances.
I'm sorry,
Because if Mattel lost the Bratz case, I'm going to take my chances. I thought the guy would have lost. I mean, it made sense. I mean, he's designing dolls, and there was a huge line. I really thought they would.
I'm not here to tell you you're wrong.
Yeah.
That case, I'm telling you, it could have very much gone either way. And I'm not joking, I did an hour-long CLE on it, teaching other lawyers about the case. I can send you the presentation if you have any level of interest. The biggest thing to take away from that case is make sure that everyone's rights are spelled out in the document. So,
I had a situation where I was at a job and they had an employer agreement that stated basically anything I invented would become theirs.
Yep.
But they only put this in once they found out I was an inventor. They were like, okay, you have to sign this. So now let's say I just didn't sign it. Is that like grounds to be fired? Like, was
You
that?
don't need grounds to be fired.
There's no.
There's no, as long as they're not firing you because you're black or Jewish or gay or, you know, a woman, a protected, pregnant, a protected class, they don't need grounds to fire you. So, you know, signing it or not signing it doesn't create liability for you.
Gotcha.
I will tell you that it goes back to the issue you raised before, consideration. In some states, continued employment is not sufficient consideration for an agreement like that. New York is sufficient consideration. So if you signed it today, it would be perfectly enforceable agreement.
Does it matter whether it's a W-4 or 1099?
Matters a lot. W-2 is an employee. The 1099 is an independent contractor. So you can't, if you're in 1099, absent a work for hire / assignment agreement, the employee owns it. No question. The independent contractor owns it. With a W-2, the employer probably owns it.
But if he created it on his own time, he would still own it.
Right, but you know, it goes back to what's his own time, what's within the scope of his employment. What if he does it on Sundays, but he uses his firm computer, even if it's his take-home office computer? I don't know. It's not clear. You want to be clear, but you don't want to put your blood, sweat, and tears and money into something and have your employer own it.
Also, I think the employer would argue many times that what he learned on the job, he may have used that knowledge to create something that's different, but he got all that knowledge.
Generalized knowledge is not something that the employer can own. Even if you have a non-compete agreement, you can't own generalized knowledge. You're allowed to take that to your next job. So I hear you, but it doesn't work that way. Thank goodness, because you'll never be able to work again. Okay?
So what, if anything, should employees here, inventors, do to protect themselves from their employer taking their invention? Is that something to worry about?
It is something to worry about. Assuming that there's no employment agreement in place, make sure to do it during your free time, not using employer equipment. And if it's not related to your job, I think you're probably fine. If it is related to your job, you have bigger problems.
Document.
There's also a time period too, isn't there, that make you sign within 6 months or something, what date or?
Well, we're assuming for this hypothetical that there's no agreement in place. So, yeah, but that can be anything up to 2 years in New York. 2-year non-compete is enforceable, 0 to 2 years. If you're gonna hire someone, sorry.
Lost track of where I am.
Excuse me though, but after the 2 years, you would be free and clear?
Yep.
Okay, that's interesting.
But what we're doing here a little bit is confusing issues. So we were talking about who owns things that you create. You're now talking about non-competes. Right? Non-compete is a totally different animal. What a non-compete says is I'm not gonna compete with my current employer. I'm not gonna do the same kind of business. I'm not gonna go to the same customers. I'm not, that kind of thing. And courts don't like those generally because they stop people from being in business. So, for example, in California, they're categorically not enforceable unless it's in connection with the sale of an entire business. You cannot have a non-compete. If you sign a non-compete for a California company, you can ignore it. It's toilet paper. In New York, if it's for 2 years and 2 months, it's probably going to be thrown out. Up to 2 years, it might be enforceable if it's reasonable as to duration and scope. But the employer's going to have to show why it's reasonable. But I honestly feel like this is really far afield of where we're trying to go. Though, if it's of interest to you, I'm happy to talk about it. Okay, so if you're an employee, we're talking now. You're the inventor, you're the creator, you're the one who's starting the company. If that's you, make sure you have an agreement in place. It's just the smart way to go. Better also make sure that the person you're bringing in doesn't have any pre-existing confidentiality obligations to another employer, because you don't want to buy into a problem. Ask them if they have an agreement with the former employer and ask for a copy of it if they do, just to keep yourself clear. Okay, so I think we just talked about the work for hire issue ad nauseum. Does anybody have any other issues about work for hire? I'm going to just bypass this otherwise. Okay, so I don't know if I mentioned this or not. but use equity sparingly. Let's say it again. Equity is expensive. This is gonna be a test afterwards. What's my number one lesson today?
Use equity sparingly.
Thank you very much.
I'm proud of you, though. You always say, don't give it away like candy.
My second message today.
Don't give it away like candy.
Avoid oral agreements. Are oral agreements enforceable?
Maybe if somebody else is witness.
Yeah, well, you're right. You don't have to have a witness. They are enforceable. There's something called the statute of frauds, so that certain kinds of oral agreements are not enforceable, but generally speaking, for your purposes, oral agreements are enforceable. The problem with them is that nobody remembers what the hell you agreed to. I'm telling you, forget oral agreements. I've litigated 70-page written agreements, and you get the week after the two parties sign their written agreement, they can't agree what they agreed on. So imagine now if you don't have it in writing and you have to litigate over it. Because that's what this is all about. All of this is about worst case scenario. If everyone's friends and everything's going swimmingly, none of this stuff comes up. It's when all hell breaks loose that the lawyers become relevant. Yeah.
Are emails, at least to start, anything that's enforceable?
Again, oral agreements are enforceable. So when you're trying to prove what the content of the oral agreement was, emails become relevant. It depends on the state. New York, one side of a conversation can record. New Jersey, you can't. California, you can't. Both sides have to consent. So if you record someone and you don't have their consent, it's a crime, actually. Certainly not admissible. In New York, it's okay. Probably okay in New Jersey, too.
Don't people have to be in New York?
So this is just another way of saying equity is expensive. I bat you over the head with it. If you're going to start giving away equity, make sure their strings are attached to that. You don't just want to give it away willy-nilly. I've seen too many situations where Bruce and I start a company, it's going great, and then you know what? We're 50-50 partners in the equity ownership, so we form an LLC. I don't have the membership interest, he owns the other half. And I'm loving this, I'm having the best time in my life. And then Bruce becomes commissioner of baseball and says, screw that company, I'm out of here. Now what? You know what happens? I'm left rowing, and doing it all by myself, and he owns half my company. So be really careful about who you're giving equity to and how much you're giving them. You want to have a probationary period. That means that they earn it over a certain period of time. They don't just get it all when they show up. You want to have a repurchase right. So if Bruce is my employee, my company, I own 90% of the stock. It's a C Corp now, an S Corp. And Bruce wants 10% equity. I'm going to tell him, okay, I'm going to give you 2.5% a year for 4 years, but only if you're employed with me. If you leave your employment, I get to buy it back at some nominal value of $1 a share or whatever. So that he's not incentivized to just take the equity and run. This is something that happens all too frequently. If you're going to give away equity, have a shareholder agreement, or if it's an LLC, an operating agreement, it's the same thing. That is the contract that governs how the equity gets divvied up, used, drag along, tag along, voting, bylaws, everything. It's one of the more expensive startup things, figure $5,000, but it's extremely worth it. As I said before, super important to maintain corporate formalities. Excuse me. Because if you don't maintain corporate formalities, you might as well not form the entity. Okay, that means you have to have regular meetings. You have to have minutes of those meetings. By the way, meetings, if it's a single member or a couple of members, you don't have to sit at a table in a law firm with a gavel and water and a pad in front of everybody. It can just be hey, how you doing? Good. What do you think? Fine. Okay, bye. But then you have to have minutes of it. Has to be a real meeting. Have to keep the bank accounts separate. Because if you commingle funds, later, if you get into a lawsuit, God forbid, you're going to find out that the corporate entity is going to be disengaged, disregarded. Okay? So you have one bank account for the corporate entity and your own bank accounts, and don't mix them up. You want to have insurance, if you can afford it. You want to have whatever licenses you need to have to operate the business. Contract should be in the business name, not in your name. And don't run personal expenses through the company. Just the company's the company, you're you. Think of the company as another person, because that's what it legally is. The objective is to avoid piercing the corporate veil. Okay, so that piercing the corporate veil means the corporate entity is disregarded. If you do that, you lose all your protections. You don't want to have that happen. Okay, I promise you we talk a little bit about IP. You guys get bored? Is this going on too long? You don't want to be inside my staring place today. 27 years later of practice. Okay, so IP is a business asset. It's probably, at least at the beginning, your most important business asset. You don't have sourcing yet, you don't have customers yet. What you have is IP. What is IP? Well, there's patents, there's copyrights, there's trademarks, trade secrets, and to a lesser extent, domain names. Let's talk 5 seconds about what they all cover, okay? A patent, it covers a useful article. It used to be business methods, but those are sort of dead now. So an invention, it's what you think of when you think of an invention. That's a patent, okay? They have a very limited term, and they're very geographically limited. So if you get a patent today, or you file for a provisional in the United States for today, and you fight, and then proceeds to be a full utility patent, you have no protection any place but the United States. If someone from China finds that utility patent and finds that you haven't protected it in China or in Australia, they're free to practice it, copy it, and go register themselves. Okay? Copyrights. Copyrights protect original works of authorship. They don't cover useful inventions. Only think of it as artwork. Artwork's a pretty far afield thing because it also, like mask works. Anyone know what a mask work is? It's the design of a microchip. It protects that. So it's a little fun, but for your purposes, think of it as a piece of art. Whether it's a painting, a book, you know, the design of a belt buckle, that's a copyright. Copyrights are, for the most part, international. If you get a registration here, you're pretty much covered for the whole world because there's enough conventions in place. You don't have to register a copyright to have protection of the copyright. The second you set an original work down in tangible form, you own the copyright. Can't do anything with it. You can't sue to enforce it until you register it. But you could register it 2 years later if you want to. Technically speaking, though, you have a copyright. Trademarks. Coca-Cola, Google, Apple. It's the name of your company. It tells consumers who your company is and what they should expect from your company. If I go to a McDonald's restaurant, I know what I'm going to find there, right? Because of the trademark, McDonald's. As a matter of fact, there was a famous case in which there was a chain of hotels started called Mick Hotel, MC Hotel. It was a low-end, cheap hotel chain, and it was communicating based on the McDonald's brand. Here's what you get: cheap, quick, clean, easy. McDonald's sued. Did McDonald's win? Oh yeah, hell yeah. Yeah. Trade secrets. What's a trade secret?
Formula. A recipe for Coca-Cola.
Right. Can a trade secret be a patent? Okay. Here's the difference.
It's not a secret.
Right. A trade secret is something that you keep secret. If you patent something, you have to disclose it publicly. The upside of a trade secret is it can last forever. Patents have very limited terms. Trade secrets can go on as long as you keep them secret. They have to do 2 things. They have to give you a competitive advantage in your field, and you have to keep them secret. But keeping them secret means you have to try to keep them secret. If you have it on your computer, but anybody in your company can access that computer, you probably lost your trade secret. If it's under password protection, and you only give it to your top 3 people, you're good. Coca-Cola is the classic. Exactly right. They've litigated, they've lost cases. They've been sanctioned before they'll give up that formula.
Is a trade secret, is a conversation with their lawyer as well?
Well, that's all privileged. That's all protected anyway.
But do you recommend that some, you know, company with a trade secret have that conversation with a legal advisor?
Well, I recommend that any company for any reason have a conversation with a lawyer. Absolutely. But if you're worried at all about whether you have a trade secret or not, discuss it with your lawyer. You're not going to give that up. the protection by having that conversation. It'll give you some level of comfort.
But then you're giving it away.
Not if you're talking to a lawyer,
Okay.
because you're under confidentiality. It's all about confidentiality. The lawyer will get this part. It's not worth it, trust me.
Can you trademark a process?
No, just the name of the process. Okay. Okay. Sorry, I'm talking too much because I'm like, you're good. Yeesh. Okay. What kind of things, you know what's fun? Yeah. Well, listen, I've lost track of what actually fun means anymore. Okay, founders or shareholders agreements, what are the typical things you're gonna see? Is this something you guys care about or no? Yeah?
Yes.
I see 3 heads nodding.
I do.
Okay. Right of first refusal, what does that mean?
That they have to give you the exclusive right to buy it or have it before they give it away.
So if you and I, if Bruce and I form a company, and Bruce then wants to sell some of his shares to her, right of first refusal means he has to offer them to me or to the company first, so I can control who I'm in bed with. I may not want to be in bed with her, sorry. I may just want to be in bed with Bruce.
Understandable.
Yeah, well, listen, right.
Can we edit that?
So that's the right of first refusal. Drag, this is actually pretty esoteric stuff. So we're gonna skip that. Incorporation, as I said before, these are sort of what you can expect to pay. Corporate in Delaware, $320. To organize, this just tells you what you expect to pay. But you can find it out by one call. But again, remember what I said to you before? This is what someone might quote you. What does it really cost? It's going to be dramatically more. Rule of thumb, everything takes 3 times long and costs 4 times as much as you think it's going to. If you haven't done it out yet, that means you haven't tried.
Oh, that's interesting.
Right? It's just, that's the way the world works. There's always going to be expenses you haven't budgeted for or thought about. So it helps to go to someone who's actually done it before, which I think is one of the values of this organization, right? Can I ask, are all of you people, or generally, are you people who have ideas and don't know how to commercialize them? Or are you here to share ideas about commercializing? What's the, is it both?
Yeah.
All right, so some been there, done that, and some trying to find my way there. All right, so that's really good. It's great for the people who haven't done that yet. I'm gonna skip ahead a little bit. What kind of mistakes do we commonly see? We've been talking about this as we've been going along, but we'll recap. Improper or non-existent non-compete and invention assignment agreements. Very common mistake. And you'll find yourself really unhappy about it down the road. Employment agreements without market terms for severance or other items. So if I hire Bruce and then the severance deal is he gets 2 weeks vacation if I fire him, 2 weeks severance and nothing else, he's gonna be an unhappy camper, especially if I have a 2-year non-compete in there. Inappropriate use of titles, you give away like candy. These people may be able to bind your company and you may not be too happy about that. I don't care about the outrageous nepotism, that's... Issue some stock to non-founders. Establishing unreasonable valuations by selling stock amounts of equity at higher prices. Having dozens of small investors because it gets unwieldy, because every time you have to do anything, you may have to get approval from too many people. Selling preferred stock in small amounts, resulting in rights and preferences that you then have to figure out later. I had a client come to us. She'd written a book. It was a best-selling children's book. It's a really good book, really well-known, very famous. And she'd taken the book and put the copyright into an entity. And her idea was she wanted to commercialize it beyond the book. She wanted to do a movie. She been approached about doing a couple of movies about it. She wanted to have children's rides at Disney and wherever. She had a clothing line. She had all these ideas. And then she broke them up into individual subsidiaries, wholly owned subs of her holding company. They held the IP in the book. And then she sold pieces. And you know what happened? She oversold it and she got nothing done. And she came to us and said, I've got all these partners who've invested and they all want to cross-collateralize into all the other businesses and I can't do anything. What do I do? We told her there's nothing, you're screwed. Unless everyone's gonna consent, you set yourself up in a structure that we can't do anything with. Remember I talked about not making an overly complicated structure?
Who is that the fault of? Did she just tell an attorney and the attorney didn't say no to something stupid?
I don't think she had an attorney.
Oh, boy.
You know, pay me now or pay me later.
I'll pay you now.
Thank you. Other mistakes. You need a board of directors, you have to have bylaws, you have to have minutes of your corporate meetings. Again, it all goes to making sure you have a real corporate entity. I think this is really beyond the scope of this conversation. This is something that comes up on a regular basis. Everybody here know what open source is? Yes, no, maybe?
Tell us,
Yes,
please.
yes.
Okay, so there are open source softwares out there that people have decided they want to make generally available to the world to commercialize, to use, to put into your own products, and you have to pay for it. But every open source company has its own set of rules. And if I take open source from Bruce's open source and I build it into my product, and I then want to sell my product, there are rules about what I can sell, what I can't sell, what I have to share, and credits I have to give. And it's very easy to screw those up. It's very easy to forget to think about them. So be careful about using open source, okay? Another problem, poor non-existent patent writing and strategy. You can do your own copyright registration. It's a $25 online form. You don't need a lawyer. I've had people come to me and I've told them, here's what you do, don't bother me. I got other things to do. You can even do your own trademark. I don't recommend it because the filing fee is $275, $250 now, but it's easy to screw up, okay? You gotta know what's related, what's not related, how to write the description, but you can't do your own patent. I've had people trying to do their own patents. It's a terrible idea. Don't do it, please. Better to keep it as a trade secret than not go to the right patent guy, or patent lawyer. When you're doing a patent, you have to list specifically what you're claiming rights to, and what you're practicing, and what your art is, and what the prior art is. And if you screw any of that up, you can give away your patent rights. So I would really urge you not to do that yourself.
Is that in the provisional stage as well?
Provisional you can file. You can do a provisional if you want to buy yourself some time. It's a one-page form. I'm okay with a provisional, but not a utility. Everyone know the difference?
No.
I heard everyone went like this and they heard no.
Give a brief overview if you could.
It's a provisional application is a holder. It's a one-page form and it's a holding place. It's a very simple form, and what it does is it buys you the right to file your full-fledged application within the year after you file your provisional. You can't screw up. It's hard to screw up a provisional application. And that gives you a lot of, if you disclose something publicly, the clock starts to run and when you can file a patent. If you do a provisional, you've bought yourself a set amount of time. The problem with it is, sorry?
Okay, that was a very important thing my lawyer told me about.
Yeah.
If you put
Publicly-
something out public, I mean,
The clock
you
runs.
tell your friends about it.
You're done. You could be out.
I had no idea about that.
Right, and it's really,
Talked about that
yeah,
for 4 years.
yeah, so be aware. Yes,
What if you file that provisional and the year passes and you haven't filed for, the full patent?
you're screwed, you're done, you're out. That's the downside of a provisional. If you don't get it in.
renew it?
No, you can't renew a provisional.
Could you file just another provisional?
You
If
can
you
file
have
it-
new subject matter, you
It has to
can.
be a different invention. You can't file a provisional for the same thing, because what you've done is you've taken it, you put it into the public domain at that
What
point.
if you change something slightly on it?
Then you could get a registration for the slight change, but not for the underlying technology.
It wouldn't extend you a year? No.
It would extend you a year for that slight change.
So you better know what you're doing.
You better have some idea.
Of what the invention is before you go out.
Can somebody else run with the provisional?
I'm not sure you said.
Well, you're filing it, so then obviously there's other people who know about it.
Well, it's just holding a place, so it's not
Yeah,
filed, is it?
but listen, patent rights, you don't have any rights until the patent issues. So regardless of whether you file provisional or utility, until such time as the patent issues, anyone out there is free to do anything. Patent applications, I think they still are. No, they're not. They used to be confidential, but I don't think they are anymore. For that very reason, but now I think they're public. Someone back there, yeah.
Oh yeah, speaking of that provisional, so like a year after you file it, say you can just let it lapse, you're like, I'm not gonna do this yet. 2 years later, you wanna do it, right? It's not on the market, nobody's done it. You could still actually file a patent though. It's just that it start no.
No.
It wouldn't start from that time of patent.
Gone, forget it.
Because
So you
really,
really have to think very
so
carefully.
that means that they must look at it when they look at your patent because
You have to
technically
disclose
they
it.
don't. Okay.
You have to disclose it. If you've done it and you haven't disclosed it, that's fraud, and if anyone ever looks, you lose
First
your
to get
patent.
to the market.
Yeah, no, because I've been told like they don't really even look up at
This
the
product may
provisional.
never get invented.
Product won't be patentable.
Oh, that's what it is.
Yeah.
You mean for you?
Listen, what a patent does, it gives the owner of the patent the monopoly for a very limited time. That's all it does. And if someone wants to practice that patent, they pay a license fee to practice that patent. But the trade-off is you get a monopoly for a limited time. So you're the only one in the world lawful or in the jurisdiction lawfully allowed to practice it. But it doesn't. If you can still invent something and you keep the technology or the know-how as a trade secret, it doesn't. That trade secret's gonna last forever.
Tough these days.
But keep in mind that you have to, copyrights, one registration, you're done. Patents and trademarks you have to maintain. You have to file periodically. And there's filing fees associated with that. Otherwise you can lose your rights. Yeah.
I was asked if I wanted the patent to be in my corporation name or in my name personally, and that was the first time I'd been asked. I've done several of these. That was
But you
first.
can't patent, you have to patent in the inventor's name. When you file a patent application, it cannot be in the corporate name.
So why did they ask me? Why did
Because
he
they
ask
didn't know what they were doing. Honestly, you can't file a patent in a corporate name. You can assign it, but you can't file in that name. So they may have been asking who you ultimately wanted to own it,
Right.
but it couldn't be filed in the.
Okay, so maybe he asked me who ultimately I wanted to own it. Is it better for the inventor to own it or for the corporation to own it?
Defined better. I mean, it's gonna vary from situation to situation.
Okay.
If you're looking for outside funding, it's gonna have to be the entity that you want to get funded. I mean, most likely. But then you also, if the individual owns it, you have liability and infringement issues. So it really, I'm not trying to be evasive, it really varies with the situation.
Do you, I'm just curious, do you discuss the costs in general with like going through the whole like research of a patent and all that kind of stuff?
I don't discuss that.
Okay.
I mean, I can tell you, but I don't discuss it in this presentation. Patent, it depends, it's gonna vary a lot with what you're searching. But for the patent searches are done by outside companies. If you came to me right now or my patent partner and said, I want to do a prior art search on this and find out what's out there, you gotta figure about $1,000.
How much is it?
About 1,000. It's not prohibitive. If it's a very complicated technology, it might be a lot more than that. If it's design, it might be a lot less. But I personally hate design patents, so I would tell you not to do it, but figure about 1,000. Why do you hate design patents? Because they're very easily worked around. In a design patent, all you're getting is that very specific design. If you tweak it in any way, you've worked around the design. Almost done, by the way, so not so doable. Yeah.
Will those head shakes be available in what you send out?
Yeah, all those head shakes are in the
Those pages.
42-page presentations. So going forward, it's almost a checklist. These are the things I want you to think about. Now, we didn't talk about A3B elections, and we're not going to, it's too complicated. Think about the IP aspects and protecting those rights. Think about your management team, what you have to pay them in cash, what you have to pay them in equity. Standard. Say again? You're gonna have to give away some equity. Just do it properly. In other words, if you have an advisory board, don't give them 5% a year. Give them 3% or 2.5% over 3 years. If you're gonna have a president, you don't give him 20% of the company when he might be gone the next week. You know what I mean? Founders' equity, you gotta think about dilution versus protection of the founder interests. But the founders are always gonna get diluted when money comes in. Everyone know what dilution means? Yeah, good. You gotta think about taxes. Taxes are huge. They drive so much. If anyone wants to talk to me later or call me or email, I'll explain what the A3B election is. It's a very important thing, but I've been here way too long already. I babble. So buzzwords. These are all good. Remember I said there was gonna be a test? We talked about the difference between S Corp and C Corp. Anybody not clear about what those differences are? S Corp, no double tax. C Corp, double tax. We know who the founders are. We know vesting of your stock.
No? Ah, okay. So what does it mean to vest over your stock? I give Bruce 20% of my company to come work with me. Do I give it to him all at once?
No.
No, why not? Because if he has my 20%, he could leave the next day until 20%. What I want to do is lock him in. So I'll tell him, Bruce, you can have 20% of my company vesting over 4 years at 5% a year. So he gets 5% of that company, that equity every year, up to 20%. If he leaves after 3 years, he's vested at 15%. Usually you do it quarterly. It'd be monthly, it wouldn't be annually, but that was just for ease of. Restricted stock. Restricted stock means there's a limit on when you can and can't sell it, or other restrictions. Incorporation we talked about, executive summary don't worry about, business plan is way beyond this. IP we talked about, common preferred stock, probably beyond the scope of this discussion. Dilution we talked about, licenses, spin outs we're not going to talk about. And that is it. I hope that was not too much. So take a picture of that, or call Bruce, or email Bruce. If you have questions, or you want a copy of this, or anything else I've done, please let me know. I'm happy to send it.
Would you be willing to take some questions?
Yeah, of course. If there's anything left to ask. Yeah, does anybody have any questions? I'm happy to take any questions. I just thought we were done.
He's from.
I was.
Friedberg, yeah, leave it up there a moment, please.
No, if you get it now, you're screwed.
We'll get this out to you though also. Randy, what about, you were talking about IP.
Yeah.
And something I encounter a lot when I work is marking. You know, they think that, oh, I have a great product, I haven't filed my patent, but I've been told I should put patent pending.
Yeah, that's fraud.
Say that again, please.
That's fraud.
Why?
Because if you haven't filed for a patent, it's not patent pending.
What
And
about,
if you then go try and get a patent, and they see that, they will cancel your patent.
what about trademark? What you do about marking things with trademark, TM on it?
You can TM anything you want. You don't have to have a registration. This is a funky country because most part of the world, you get rights by registration, not by use. Here you get use by registration, not by, by use, not by registration. So if you want to use the R in the circle, you have to have a registered trademark. If you want to just put a TM on something, free to do that anytime you want for anything. The downside is, if you haven't cleared it properly and you're claiming trademark rights, you might get a lawsuit or a cease and desist letter.
From a competitor?
From a competitor, from somebody who thinks that they have a registration you're infringing.
Okay.
So the
Yeah, the card's probably an easier way to go. I'll leave a second.
By the way, for most of you, you know we now have a YouTube channel. So all of our prior meetups are online at Manhattan Events on YouTube, and Randy's presentation will be there also. So if you miss something, or if you
Don't call you.
when you reach
Go back to the.
If you want to listen to this again. Any other questions?
Any other questions? With that, thank you, Randy.
Thank you.
Oh, thank you so much.
So for those of you that are new, sometimes we'll have a pitching panel after the presentation. Nobody had signed up for that this month. I expect we might see someone next month. But our presentation next month will be from All Star Marketing, which for some of you who have been around for a while, they are one of the leaders in, as seen on TV, marketing of products, and they are pretty reputable, or they're very reputable, not pretty reputable. I wouldn't have them back a third time. But they will be telling you a lot about what to think about as to what is appealing for a mass marketed television product. And I think there's some great lessons in terms of just understanding problem solution issues that most people go through. So that will be next month, the second Monday of every month, and we look forward to seeing you all then. Thank you very much.
Thank you. Wow.